Mr. Yeung is a member of Anthony Rogers Chambers. He's both a practicing barrister and a professional civil engineer. He has considerable experience in preparation of contract documentation and in contract administration and handling claims by contractors in infrastructure, highways, and earthworks projects. Mr. Yeung has acted as a sole arbitrator and co-arbitrator in many construction and commercial disputes. He is listed in the HKIAC panel of arbitrators, the Bar Association panel of arbitrators, and the Hong Kong IE panel of arbitrators. He has also been appointed by ICC as co-arbitrator in an international commercial arbitration involving a sum of about $17 million US. And the topic that Mr. Yeung will share with us today is third-party funding arbitration in the construction industry. Mr. Yeung, please.
Thank you. You can see from the topic that I'm going to talk about is so-called third-party funding arbitration. And in fact, when I prepared this topic, I've asked myself this sort of question. First of all, what is third-party funding arbitration? And secondly, why do we need to have third-party funding arbitration? And third is, how would this third-party funding arbitration be implemented in Hong Kong and to enable this process be done in Hong Kong? And next is, who can be third-party funding? And last is, how would ensure that this third-party funding be implemented effectively in Hong Kong? And those are the questions which we are going to look at this afternoon about third-party funding arbitration. In fact, this topic had been a hot topic about, in fact, in the last decade because of a number of cases which we are going to discuss. And in fact, third-party funding arbitration has become common in other countries, say like the Europe, say like the UK, US, etc. But in Hong Kong, that was only developed in the last decade. And in fact, just look at the other competing jurisdictions, just like Singapore. They also had this reform only recently in 2017 and also in 2021. So you can see this development is rather recent, and so that is why I think some of you may be interested in this, so that is why I pick up this topic for a discussion. And first of all, we look at the first questions to understand is what do we mean by third-party funding? So obviously, third-party funding means someone who is third-party to the disputes. They fund the litigation process or arbitration. So this is what we call third-party funding. So, so you could see that usually people treat it as a business. So that is why we have the commercial investor, and they would like to take a share of the process. And this third party provides funds, usually in the way of costs, legal costs, to the parties, so that they could have the proceedings be proceed. So of course there would be return for this investor, and the return is that if the proceedings are successful, the third party funder will receive a share of the recoveries. But on the other hand, they will also bear a risk. The risk is that if the funding, if the proceeding is unsuccessful, the funded party would not be required to pay, and all the fees, etc., legal costs, etc., will be borne by the investor. So that would be the so-called the allocation of risk and the profit. Now, with this in mind, we look at some statistical figures. So obviously, for this sort of share, we look at the UK experience. Usually under this sharing ratio, of course, depending on the winning chance of the case itself, of course, also depending on how much legal costs or how much money would be able to be recovered from the dispute resolution process, and also on the likely sharing ratio. So in just some figures for you to consider is that in UK, those cases which would attract investors' attention are those cases usually have a chance of success of around 60% to 70%. And the amount at stake would usually be required to exceed 1 million Hong Kong dollars. So that is around £100,000 in UK. And of course, the larger amount involved, the greater will be the attractiveness of this to investors. About the sharing ratio, and it ranges from 15% to 50%. So the median is 33%. But you can see those are the sharing ratio which we are talking about. So if the amount involved is large, obviously you would expect it that the sharing ratio would be lower. But of course, if the amount involved is a small sum, usually the sharing ratio will be higher towards the investor. Okay, so those are the backgrounds behind for third-party funding. Now, next is that why do people need to have third-party funding? Usually, they are those people who do not have sufficient means to finance the dispute resolution process. Now, in Hong Kong, the legal costs are, well, some people talking about astronomical figure, but of course that is some sort of exaggerated. But we all know that it is very expensive to engage lawyers. So you won't expect that a commercial cases could be, the fees involved will usually be in the order of a few millions. So sometimes, depending on the complexity of case, it may even check up to about more than 10 million and even more. So you could imagine that this sort of legal costs we are facing. So that is why people, for those people who do not have sufficient financial means, or even they have sufficient financial means, they are thinking of some other more interested topic, more interested subject for them to invest. So against two possibilities that people are thinking of diversifying their risk to get somebody, in this case the third party, to invest in their potential dispute resolution process. So that is why third-party funding becomes heated topic. Now, next is we look at the attractiveness and problems being faced. Now, of course, the attractiveness is that if we have this sort of third-party fund arbitrations being done in Hong Kong, that will bring, that will first of all promote the Hong Kong's reputation as an arbitration center. And secondly, is there are associated profession which can benefit from the increased number of arbitration cases in Hong Kong. So that is why Hong Kong sees that that's a business opportunity, and that is why Hong Kong is trying to use this as a mean to promote third-party fund arbitration in Hong Kong. But there is one big problem being faced in Hong Kong is that the common law still regards the maintenance and charity as an offense. Not just an offense, it is also a civil tort. So in both regards, it is a civil and criminal wrongs. Now, it is against this difficulty that people are trying to look at how this problem can be resolved. And that is what the maintenance and charity is defined under common law. First of all, as I said, they are civil and criminal wrongs, and before the amendment of the third-party funding amendment ordinance, they are regarded as being applied to arbitration proceedings. And I give you a definition of maintenance, which is directed against wanton and officious intermeddling with the disputes of others, in which the defendant has no interest whatever, and whether the assistance he renders to be the one or other party is without justification or cause. So this is the definition of maintenance. Champerty is also a form of maintenance, but the difference is that there is a sharing of a portion of the amount in dispute. So you can see that maintenance is a wider and champerty is slightly narrower in that it has some sort of sharing. And under common law, it is provided under Section 101I of the Criminal Procedure Ordinance, talking about it, that it will be a imprisonment of 7 years. So you will see that this is a very serious offense. So that is the problem being encountered. And of course, common law is still applicable in Hong Kong under the basic law. So, that is something which really troubles the petitioners and also the investors. And I draw a timeline as to the relevant cases which I'm going to talk. And essentially, there are 2 cases which concerns about the champerty and maintenance. And the first one is Unruh and Seeberger. And this was decided in 2007. And then followed by another case of Winnie Low and the Hong Kong government. And these are the 2 landmark cases about the maintenance and champerty. And you can see subsequently there are development by the Law Reform Committee, and with the legislation being enacted and code of practice being produced by the Department of Justice to enable this be done in Hong Kong. And we first look at the case, which is a landmark case decided by Court of Final Appeal, and you can see that was decided in 2007. So that was about 15 years ago. And the facts of this case is talking about 2 individual persons. And Seeberger is an investor, and he wished to buy a company owned by Mr. Unruh. And before the date of completion, there was an arbitration between the company and the famous group of Benetton. In fact, Benetton and Boulevard, they are talking about watch selling business. And the place of arbitration is in Netherlands. So the place of arbitration is not in Hong Kong. And on 19th of September 1992, these 2 gentlemen entered into a memorandum of agreement talking about the sharing of the compensation. And Mr. Unruh is obliged to provide endeavors to Mr. Seeberger, and in return for any money he received in excess of 10,000, in excess of 10 million, he would get a bonus of 10% of any amount in excess of this. The arbitration case was settled after the acquisition, and Mr. Seeberger refused to pay Mr. Unruh the special bonus, and that is why the case has been taken to court. Now, the argument on this is whether the special bonus agreement is champerty, whether this is a sharing of the process of the litigation result. In this case, it is the arbitration result. Okay, so you can see from this timeline that I've set out the license agreement, set out how the arbitration was commenced, and then all the relevant matters have been stated here. So I don't think we need to go to details, but the issue is about the enforceability of the memorandum of agreement, whether that is champerty and contrary to public policy. That was the issue before the court. And then in this case, the CFA held that, first of all, the doctrine of maintenance and champerty continue to have effect in Hong Kong. And the court also identified 3 categories where liability for engaging in maintenance of champerty could be excluded. These are the famous 3 exclusion category. The first one is common interest category. That means those persons who have a legitimate interest in the outcome of the litigation are justified in supporting the litigation. Now, this is the typical example. For example, you have the controlling shareholder who finance the cost of litigation or arbitration by a firm, by a company, right? So this is the typical example of common interest category. Number two is cases involving access to justice consideration. So if you are having a rich man who sees that there is a poor man who has a good case, and he wishes to provide finance for him to fight for his benefit, so that would fall within the access to justice consideration. So that you may say that's within the moral standard. You may say that's common sense, but anyway, that's the case talking about second category. And the last one is a miscellaneous category of practices accepted as lawful, such as the sale and assignment by a trustee in bankruptcy of an action commenced in bankruptcy to a purchaser for value. So that's the typical case of insolvent company or bankrupt person who has a good case, and then the official receiver, when the person is declared bankrupt or the company declared liquidated, the liquidator sells the case, the whole case to an investor. So that is also common in Hong Kong, and that is regarded as lawful. So now these are the three categories which the common law recognized to be an exception to the doctrines of maintenance and champerty. Now, in construction industry, we all know that in the case of NSC, nominal subcontractor, when they wish to recover their money, the problem which they usually face is that the contract is between the NSC and the main contractor. So they do not have a privity of contract between the NSC and the employer, right? So in this case, how could the subcontractor do? Of course, they could sue the main contractor, but the main contractor will usually say that I do not have money. I have not received the money from the employer. So in fact, there is a pay and pay clause. So against this basis, I am not obliged to pay you, right? Now, so in order to avoid this argument, in Hong Kong, we also have the so-called name borrowing provision. That means the NSC would have a chance, in fact, an option for using the main contractor's name to sue the employer for the amount of work done by the NSC, which is also part of the main contract works, right? Now, so this is a typical situation and quite commonly occurring situation in Hong Kong. This is not regarded as against champerty, even though the case is run by the subcontractor using the main contractor's name, right? So this, you may say, fall within the third category of three, but sometimes if you are using legalistic analysis, it doesn't fall within the champerty arrangement, right? So, so that is essentially what's been said by the case of Unruh and Seeberger. And then the CFA, the CFA has expressly left open the question whether maintenance and champerty applied in agreements concerning arbitrations taking in place in Hong Kong, as it did not arise in that case. Now, it's been set out in Paragraph 1 Act of the judgment, saying that it's common ground that the doctrines of maintenance and champerty are unknown to Netherlands law. So it is, in other words, not against Netherlands public policy for a third person to provide assistance to support a case, to support to a party to an arbitration or to legal proceedings in that jurisdiction, whether or not for a share in the process. Now, assuming for the purposes of this argument that the MOA would, as a matter of pure domestic law, be regarded as champertous, should the court refuse to enforce it, being a contract made in Hong Kong and subject to Hong Kong law on the ground that is champertous, notwithstanding the absence of objection under Netherlands law. So now that was CFA's opinion, and then the CFA held that it should not strike down any agreement providing the third-party funding of arbitration on the ground of maintenance of champerty where such arbitral proceedings are seated in a jurisdiction in which there's no public policy objection to such funding. Now, so that's the dicta of CFA. Now, so applying this logic, so if you are talking about a third-party funding arbitration, for example, in the United States, for example, in UK, for example, in most European countries, say like France or Germany, would this agreement be struck down? The answer by CFA is no, right? So you would be able to hold that such an arbitration, such an agreement is not tremendous, right? So that is essential. But as far as Hong Kong, CFA has deliberately reserved its position. It said because this case does not arise, does not have this problem of arbitration in Hong Kong, so CFA refused to give any dicta or any ruling on this matter. So that is why the matter needs to be discussed in public, and Law Reform Committee was set up to deal with this topic. Okay, so it is against this background that we have further discussion about this. Right, now, okay, now the next case which we are going to is, of course, a criminal case, and Winnie Low is the solicitor handling a personal injury case. And in this case, the court discovered that Ms. Low, when she was acting as the solicitor of the victim, when the victim brought an action against the driver of vehicle in which the son was a passenger, the victim's son was injured and brought an action against the driver and also the insurer for the damages which he suffered. Right? Now, because the son was an infant, so the son, the case was settled at 3.5 million as the amount awarded to the son. But because the son was an infant, so it requires court settlement, court approval of settlement, right? So when the master looked at the case and found it that a portion, in fact, it's 25% of the settlement amount would need to be paid to the solicitors, then the court raised a doubt whether this was tremendous, whether that was against maintenance and tremendity. So that's why the matter was sent to criminal court, and the court after trial convicted the solicitors for offending this common law, right? And then the matter took to the Court of Appeal, and Court of Appeal reviewed the common law development of tremendity and maintenance. And then, so you can see from the fact that it showed that, in essence, what the solicitor's fee was somewhat like a contingent fee basis, but slightly more than contingent fee because she also shared the proceeds of the result of litigation. And what was held by the CFA was that the scope of what constitutes maintenance and tremendity in Hong Kong has been narrowed over the years, and that reflected change in public policy consideration. But even so, and then the exceptions were stated. And then paragraph 177 to 179 is said that the question whether and to what extent criminal liability for maintenance should be retained in Hong Kong. And then in England Wales, this was abolished, and also in Australia. But the issues are of some complexity and may involve taking a different view in respect of maintenance as opposed to tremendity, and of criminal as opposed to tortious liability. And it is, in my view, a fit topic to be referred to the Law Reform Commission. Now, so you can see that the law had confirmed or affirmed the common law offense of tremendity and maintenance still applied to Hong Kong. But the court also said that because of change of the social environment, this matter needs to be revisited, and that should be a topic of Law Reform Commission. Now, I just pause here is that obviously in this case, the court found that the contingent fee, or in this particular case, the sharing of the process of litigation is against common law, right? So this system of contingent fee or system of sharing of civil process or sharing of process of litigation have been used in other jurisdictions, but still the court, the CFA confirms that that should still be applicable to Hong Kong. So that brings Hong Kong a different scenario from the other jurisdictions, right? So we then look at what the Law Reform Committee is doing. So what the Law Reform Committee is doing is that they confine or they reduce the scope of trumpery and maintenance, and that is not applicable to arbitration. But they deliberately leave this matter still applicable in court, right? So for those matters which I refer you later, I have to clarify this, that those new provisions, they are only applicable to arbitration. For court, for example, civil court and criminal court, the contingent fee system is still, at the moment, against maintenance and jeopardy. Okay? Now, and then I gave you a timeline as to the third-party funding for arbitration subcommittee. So that was set up by the CJ and S4J, and then the matters look at is, now if the removal of jeopardy and maintenance to arbitration proceedings in Hong Kong, there would be some benefits. And the first one is, of course, the bringing Hong Kong to a more competitive position, and that is what the LLC consider. Because first of all, Hong Kong is a renowned arbitration center, and if we avoid to have this sort of legislation, that means that our competitors, our major competitors, will take over our position. Now, just a matter of history is at that time, Singapore still maintains jeopardy and maintenance, right? So that was at the time of LRC when they produced the report. But after Hong Kong has enacted the amendment ordinance, Singapore, as usual, they acted quickly. So in 2017, they also changed their law. So the jeopardy and maintenance is no longer applicable to arbitration proceedings. And in fact, in 2021, they will take things one step further. So now in civil court, there is no jeopardy and maintenance in Singapore, right? So you can see Singapore has acted very quickly. At the moment in Hong Kong, we only have this removal of jeopardy and maintenance to arbitration proceedings only, but not to other civil court or criminal court. Okay, now then we have the other advantage of bringing more job opportunities to Hong Kong. Of course, that's understandable. Now, next is that for the precedent judgment, because CFA has got these two decisions, so the legislative intent is to reserve those. So we are not changing the law by reversing the judgment. We still follow the judgment as I have just said. And the merit, the other point, the other advantage is that for those whose case have merits, and if we could allow third-party funding arbitration, that will benefit them. So that is another advantage. And last is the LLC draw a distinction between arbitration and litigation. Now, because litigation is in the court, and the court expenses are from the community, from the government. So unlike arbitration, arbitration is a private agreement. So they should be given more freedom. So that is why we think that if we look at why common law prohibits jeopardy and maintenance, The reason is to reduce the number of litigations, reduce unnecessary litigations. But if we apply this theory to the commercial disputes, they themselves should be mature enough to look after them, especially most arbitration cases involving company. So the commercial companies, they should be more watchful about their interests, right? So again, this is one of the main distinguishing figure why LLC at that time thought that those maintenance penalties should be removed from the arbitration industry. Okay, now then we look at the legislation which was done by the amendment ordinance, and you can see that that's by introducing so-called Part 10A in the amendment, and that would took effect by saying that common law offense of penalty and maintenance would not apply to arbitration. And then that was done, and then the code of practice was also issued by the Secretary for Justice, and you can see from this timeline. So starting from 1st of February 2019, everything is ready. So the legislature has been implemented, and then the Secretary for Justice has issued the code of practice. So, so you can see I've just extracted some of the relevant provisions in the amendment ordinance to show the purpose is to ensure that the third-party funding is not prohibited by particular common law, and then it provides for measures and safeguards in relation to third-party funding of arbitration. And then particular common law offenses do not apply for the case of arbitration, and tort also does not apply. And more importantly is that Secretary for Justice has issued a code of practice for third-party funding of arbitration. Now, this topic has been discussed extensively in the Law Reform Commission when they consult the public. I think the concern at that time was that whether that would generate a lot of unnecessary dispute, even though we are talking about arbitration. So in order to provide some sort of safeguard to this, the Law Reform Commission had taken into account the other jurisdictions' experience. Now in UK, they do not have this sort of code of practice being done. Instead, they have their own trade union, so that they would have this trade union of investor. The union had devised some sort of rules for the members to follow. Now in Hong Kong, we don't have this sort of, although we have some investor people, we don't have this sort of union, so it is not realistic to provide union rules. So instead, it was resolved that Secretary for Justice would issue code of practice for providing some sort of guidance to third-party funder and also the party who will be receiving those funds from the third-party funder. Okay. Now, so you can really understand it that if we talk about third-party fund arbitration, it is essential that the third-party funder and the funder party, they should have an effective and also a fair agreement, so as to apportion the risk and the profit which they obtain between them. Okay, so that would be the intention behind for having some sort of guidance or some sort of control over the agreement between the third-party funder and the funder party. So we now look at the code of practice. You can see, although the code of practice is a, well, I won't say voluminous documents, but this document contains a number of sections. But you can see, first of all, it starts off by saying who can be third-party funders, the scope of court in order for this code of practice to cover, etc. and conflict of interest, etc., etc. So you can see from this quote that first of all, it defines who is the third-party funder, and secondly is that the scope is to apply to funding agreement commence or enter into after the day of commencement of the code. And then we can also see there is some sort of control on the promotion materials, saying that they should be clear and not misleading. And then defining what the essential elements of funding agreement. And the third-party funder must take reasonable steps to ensure the funding party has received independent legal advice and have Hong Kong address for service, set out extensively the funding agreement and the naming contract basis, etc. And then now next is that it is essential because the third-party funder who would be required under the agreement to provide fund. So it is essential to see that they have sufficient capital to meet the requirement. So the amount has been discussed, and now in Hong Kong we've used the 20 billion as the capital minimum requirement for capital, and also that this has to maintain for a minimum period of 36 months. That's also important because otherwise the money can be easily diverted away in order to avoid any potential disadvantageous situation. Okay, now not just the figures, but also requiring audit opinion and also qualified third party to make sure that this minimum capital requirements are met. And then the capital adequacy would also require that the third-party funder, if they have any change, usually adverse to their capital situation, to notify the fund party so that the fund party could decide whether to continue with the support or the so-called the third-party funding agreement with the third-party funder, right? So you can see that's for the protection of the funded party. Now, next is about the conflict of interest. This is also important. Say, for example, if the third-party funder and the funded party hold different view as to whether the proceeding should be continued or not, right? Now, that's also essential. And there is also a possibility that the third-party funder may usurp his position, may usurp his influence, and reach a settlement agreement or reach the result which is disadvantageous to the funded party, because the third-party funder may have some hidden agenda with the party who will be sued by the funded party, right? So in order to manage the conflict of interest, the code or practice has provided some sort of mechanism to this, so that you can see that these matters have been set out effectively as to how to manage this sort of conflict of interest. Okay, so because of lack of time, so I don't think I could have sufficient time to go through this. But in case there is a dispute between the third-party funder and funder party, let me see. Sorry. Now, that is something which I'm going to at a later section if there is a dispute. But it also provided for the liability of adverse cause is that this is also set out clearly in the third-party funding agreement as to who should meet the liability for adverse cause and whether premium is required, etc. Right? So that would be essential data required to be entered into the third-party funding agreement. And of course, I mean, there must be some sort of provisions as to how this agreement will be terminated. Of course, if the contract comes to an end, if the if the result comes to an end which is happy to both parties, then we do not need to resort to this grounds of termination. But usually dispute arises, especially during the course of the cases, when evidence evolves and when more evidence comes up, then originally the parties may be optimistic about the result of the dispute resolution, but later on the evidence comes out and it shows that their case is a bad one. So how would this be dealt with? Then that would, one of the way, of course, is to for the third-party funder to walk out from the termination agreement. So that would be some sort of grounds where the third-party funder could walk out from the third-party funding agreement. Okay, important in Section 2.14 is that the funding agreement must not establish a discretionary right for a third-party funder to terminate the funding agreement in the absence of the circumstances described in paragraph 2.13. So that is some sort of restriction to the third-party funder, so that they could not just say that I don't like it, so I just walk out. So that cannot be the case. So they can only be walked out under this grounds of termination in Section 2.13. Okay, now then also the funding agreement should provide the funding party could also terminate a contract if they reasonably believe that the third party had committed a material breach of the code or the funding agreement. Okay, lastly on this one is the dispute regarding funding agreement. So if there is a dispute between these two parties to the third party funding agreement, how would this be resolved? So very likely that there will be an arbitration within an arbitration, right? So that is a realistic situation, and that happens in other jurisdictions. Okay, there is also campaign procedures. Campaign in the sense that they could campaign about those matters set out in Section 2.18. This was provided by the core practice, and then the third party would also be required to provide the reports to the advisory body. So essentially, the advisory body is still set up by the Department of Justice to monitor and control so that we won't have this sort of loan shark entering into the third-party funded industry. So that is something which they are worried, and that is what they try to do, is to have some control, in this case by annual reports, etc. Okay, but more important is on the consequence of non-compliance. So surprisingly, I mean, for the consequence of non-compliance, it does not render any person liable to any judicial or other proceedings. So the court can only draw adverse inference, or the arbitrary tribunal draw any adverse inference to take a look that they do not comply with the core practice. So that is the what's been said about the consequence of non-compliance. I mean, to me, that seems to be quite strange. And now we come to the conclusion. So in this case, the Hong Kong as a major arbitration center, and of course we try to unblock any possible block to maintaining the competitive of Hong Kong as a major arbitration center. So this is what's been done by removing the common law of treaty and maintenance in arbitration proceedings, and hopefully that could attract a number of investors to come to Hong Kong to actually invest in those construction disputes. Now, in fact, my experience is that some of the investors, they do have strong interest in those disputes, especially for those disputes where the subcontractor, because they do not have sufficient money, they wish to sue against the main contractor. So those cases, in fact, my experience is that I have been briefed to advise on the merits of those cases. and to see whether this matter should proceed or not. So I would think that these cases would become more and more popular in Hong Kong, and especially in Greater Bay Area, we have a lot more construction activities being ongoing. So these are matters which I think would bring more opportunity to Hong Kong construction industry. So so that is why I think it would be more useful for you to know more about this third-party funding arrangement in Hong Kong. So probably that would be a convenient moment for me to end my talk here, because I know that I'm now at 2:57. So that would be the end of my discussion.
Thank you, MT. Please remain on stage for the Q&A. We have one question here. Is there any third-party funding arrangement allowed in doing arbitration in PRC or Greater Bay Area?
Yeah, I think that's a good question. In fact, I've done some research and also talked to some lawyers. Essentially, in PLC, we don't have this sort of legislature, just like what I say, common law, forbidding the tremity and maintenance agreement. So the answer is that there is no such law or legislation forbidding the tremity and maintenance agreement. In PLC, in fact, before 2016, that was not common to have this sort of maintenance and tremity in PLC. But since 2016, it has now become more and more common for this matter. Because, in fact, you probably noted that in PLC, contingency fee agreement is acceptable. Right, so if you look at the mainline film series, so you can see a lot of lawyers. They are quite rich men because they have a share of the process. But of course in Hong Kong we don't have. But in PLC, because they have this sort of contingency fee arrangement, so that is why the requirement for this removal of maintenance and tremity is not so imminent as like in Hong Kong. So so that is my understanding. But now there are more and more cases on this investment, third-party funding investment in PLC. In fact, starting from 2017, these cases are rising very rapidly.
I have a question, actually, two questions. One, since the enactment of this ordinance, has there been a rise in terms of third-party participation funding arbitration in Hong Kong, the number of cases? And the second one is, you mentioned that one of the annual report, the reason for submitting an annual report is to prevent loan sharks in the industry. Has that happened?
Now, in answer to your first question, I think the answer is yes. There has been a steady increasing number of cases where the third-party fund arbitration starts to work here. And regarding the loan shark, I think that will be something which the LLC Law Reform Commission is worried about. At the moment, I have not heard of this. So probably the mechanism as devised in the Code of Practice has sufficiently safeguard against this.
Okay. Well, due to lack of time, I think that will be the last question. Thank you, Mr. Yeung. Let us show our appreciation to our speakers.